All right, we're all on right now. A couple people are still sneaking in, but thank you all for jumping on this lovely Sunday. It's really nice outside, so hopefully you get a chance to go out there a little bit later. This is our call. It's Living Trust and How to Protect Your Assets. This is a really good one. Real quick about me, my name is David Sanchez. I'm a full-time realtor focused in Long Beach, LA, in the OC area. And then Kimberly, if you could say something real quick.
Yes. Hello, my name is Kimberly Smith. I'm originally from Texas, lived in New York City for a while, been here for almost a decade. I've been practicing real estate since 2019. And this subject is near and dear to my heart because my parents did not plan and it was not fun.
And that's why that's a big reason we're having the call today. And we want everyone to be able to prepare for this because things happen, unfortunately. And then Adam, you're the main man of the show. If you can give your a quick intro.
Thank you guys for having me. I'm Adam Carpinelli. I'm an attorney in El Segundo with 10 years experience. Currently working with Stone and Salas LLP. They're a law firm in El Segundo, California, and we practice business, real estate, trust and estates litigation, but we also do estate planning. And so that's what we're here to talk about today. I want to give a big thank you to Kimberly, David for having me. And I guess we can go ahead and jump into it. Let's do it. I guess just before we get started, let's see a show of hands. How many people already have a living trust? Anybody? Bueller? Okay. How many people have a family member who has an estate plan? One person. Okay. All right. So it's not all completely new. So we'll go over some of the definitions or different roles within a living trust. A living trust is the most popular means of having an estate plan in California. And basically what it is, it's a living trust is a legal entity that you create while you're alive that holds ownership of your assets. And basically you're able to maintain control of all the assets, but technically the trust owns it. So, it's a separate legal entity from yourself. And the grantor is also known as the settlor or truster. And this is a person who creates the trust. So if you're here curious about forming an estate plan, this could be you. A trustee is somebody who manages the assets of the estate, and that's somebody that you can designate, in the event that you were incapacitated, will basically be the successor trustee that takes over the management in the event that you're not able to. And so basically that person is immediately appointed. So you don't need any kind of court intervention for them to take power. They're able to step in swiftly. And that's why living trusts are the main benefit or cost saving mechanism in California. And the beneficiaries are the people within the estate who are going to be receiving the assets under your trust. And you can dictate specific instructions to them or specific instructions to the trustee of how to distribute those assets to the beneficiaries. And one thing in California that you may want to consider is actually giving something to people that even you would not want to give your assets to. And I'll explain why. So in California, basically there's an option of having a no contest clause within a living trust, which basically says that, if a beneficiary makes a claim to the trust and they don't have any probable cause to do so, then they don't inherit anything under the trust. So that's an incentive for people to not make a claim to the trust. And so in that sense, it's better to give them something so that they don't come back and make a claim. And so that's something that a person forming a trust can basically anticipate and plan for if they wanted to.
That's interesting. I've heard that in movies and stuff where someone gets something that is not of value, and that makes sense and why maybe they would do that. Interesting. Okay, a couple quick questions because Kimberly and I have had a transaction recently where these words have been thrown around. What's an administrator and an executor?
Yep. Oh, good question. Administrator and executors are basically different terms for a trustee, and they're synonyms almost, a grantor has different synonyms for settlor and truster. Administrators are the same as trustees. Key features of a living trust, and one benefit is that they're fully revocable. So if you want to, make changes or basically dissolve the trust, you're able to do that during your lifetime. Of course, that changes, as you become incapacitated or you pass away. So in that event, you're not able to, of course, make that change if you're not of capacity. And let's see, the trust will use your social security number. So as you file taxes, which, I guess is coming up for most people here, one of the benefits is you don't really have to do much of anything different to file your taxes. Of course, I'm not a tax professional. You can consult a tax professional for specifics on that. So I'll go ahead and also mention that there are some tax incentives for setting up a living trust, such as property taxes could be held the same and/or protected within a living trust. And again, these types of nuances are something that's best to talk with a tax professional about. And one of the things that's really needed for a trust to work is that it has to be funded. So it's great that, somebody takes the initiative, sets up a living trust, but then that's really just step one. The step two and the process is you have to fund it or transfer the assets into it in order for it to work. Because technically that estate has to own it, and it doesn't own it unless you make that transfer. And so that's why it's such a critical step. And in California, when people come to our office to make an estate plan, typically we'll recommend a living trust, a pour-over will, power of attorney, and healthcare directives. And basically I'll go over what these different moving parts are. And healthcare directives, I don't know if anybody is familiar with them, but basically they dictate who is to make decisions on your behalf if you become incapacitated for your own medical decisions. And so basically, forbid anybody is unable to do that, somebody will step in for you, make those decisions for you. And then power of attorney is basically the same thing, but for legal decisions. So in making decisions or transfers within your estate, the power of attorney is the one who would actually be executing and signing things on your behalf to get those things done for you. A pour-over will is basically a will that captures all the estate assets that are not included within the living trust. And it's basically like a safety mechanism where if somebody does their diligence and creates a living trust, they put all their then known assets into it and then somehow forget about some assets that come later or that did not make it into the trust, the poor will capture those, put it back into the trust. And so that's the reason for it. And so these are the different moving parts that we typically set up in California, but there are other alternatives. And yep, we can go to the next slide.
And I just want to say here, I think
Oh, sure.
for me, like I got my license in 2019 and 2020, both my parents passed away. And I thought my dad had a will, and I thought him having a will that the house would be included and all that stuff. So if someone has a home and a will, does that mean that the home won't go to this probate process?
Yep. And unfortunately not. So if somebody has a will, wills go to probate. And we can later on we're going to be talking about sometimes people have alternatives to forming a trust and or a will by using joint tenancies. And we can talk about that in a few slides as something to avoid because it's usually not the most efficient.
Yeah. And I also want to mention here on your must be funded to work. I don't know if you've come across this, David, but when you put your home into a trust, you also need to change your insurance because if you don't, you won't be properly insured. So you do have to make some changes on that when you do that. So make sure you.
Excellent point. Yep. All right. And so we'll talk about some of the reasons to consider a living trust. And we've been talking about probate as something to avoid. And the reason is because basically it could be a lengthy and costly process. Forming a living trust will save you time and money. Typically, an uncontested probate can take 12 to 18 months and could be costly. So that's one of the main reasons that people tend to form a living trust. Another reason is to maintain control. And so you can maintain control over your assets during your lifetime, dictating the distribution upon your passing before it actually happens, as opposed to a probate where things are up for grabs after your passing and or to be determined by the court, which people tend to want to avoid also. And then Another big incentive is to ensure privacy. And so in California, wills go to probate, and that's a public searchable event. And so in that sense, people can come out of the woodworks. You can have creditors come out, you can have potential fraudsters come out and start soliciting things to people along the process. And so it's one benefit to living trust is that it's completely private. And so it's basically more protected from those solicitations. The other thing that is great about them is planning for incapacity. And so it's basically a seamless transition in the event that you could become incapacitated. Somebody will step into your place immediately. And that's somebody that you trust, that you dictate ahead of time. And you have peace of mind going into it, knowing that, you're going to be protected by that person or taken care of without leaving it up to the court to determine for you or family members. And so it brings a lot of peace of mind in the process. The other great benefit is that it reduces family conflict. And so we can find that, a lot of times family members are less likely to make disputes to an estate if a family member sets up the trust, because it's, something that's predetermined, planned for. Generally, the person setting up will often have conversations with their family members. And sometimes along that process, it prevents the disputes from even coming about in that sense. So that's one of the these are some of the main reasons for it. And it seems like there are others that are not included here, such as, tax incentives. But again, those tax incentives should be talked about with a tax professional.
That was good. I like the lawyer, but you got to refer to the appropriate person. Right. And then so Kimberly and I have had a lot of trust sales in our day. And I was just curious, you said on here that it reduces family conflict. Can you give me an example of times where it has helped or has?
Definitely. Yeah. And unfortunately, it's like we don't see the parallel universes where if somebody had, estate plan set up, they could avoid a probate. We typically see the probates where family members are fighting, their loved one has already passed. That loved one didn't have a plan in place. And so sometimes the loved ones have an idea of what they think it should have been or what they want out of it. And without having what that, loved one wanted in this event. And so it's one of those situations where it can be more contentious. And so it's usually best to have an estate set up. And we also touched upon that no contest clause within a living trust. And that's a mechanism to disincentivize people from making a claim, because if they make a claim, they could get nothing. And so if you give them something under the trust, even if it's somebody you don't like, if you don't want to give that person anything, it may be best to give them something, because then they are incentivized to not make a claim against the estate. Otherwise, they'll basically be left empty-handed. And so that's one of the great mechanisms that people use, and it sometimes comes up in what we see. And so this is costs of probate and costs of an estate plan. And these are, rough examples, but in general, if you have an estate worth about $500,000, it could cost over $13,000 in attorney's fees and $13,000 in executor fees, for a total of about $26,000. And of course, these are rough estimates. If an estate is worth $1 million, it could cost over $23,000 in attorney's fees and $23,000 in executor fees, for a total of over $46,000. And so these, look like big numbers in comparison to an estate plan, which could have an estimated cost of about $5,000 for a professional to set up for you. And of course, these are numbers that are subject to change. The cost of setting up an estate can change, over time. And then also we see that sometimes if situations are more complex, it could impact the cost of setting one up. But in general, we can see that it's still a lot lower than the probate alternative. And so this is why it's a huge advantage to set up an estate for yourself. If somebody here is witty and they have some know-how within the the real estate industry, they could say, aha, I'm going to avoid both of these. And I'm going to set up joint tenancies as an alternative to an estate plan. And basically what a joint tenancy is that you can dictate in your title that there's multiple owners to a piece of property. And in the event that one of the owners passes, there's right of survivorship for the other people that are owners. And I've had a previous client who, I believe he was a real estate agent. He decided to take this route and he put his son-in-law on one of his property titles as a means of, basically determining how his house would be transferred upon his passing. But what he didn't anticipate was the fact that there's a tax assessment that occurs. And so in California, when there's a transfer for title ownership, it will often trigger a property tax assessment. And I'm sure David and Kimberly are aware of that and have seen it. And there are some exceptions to it in California. So if you're transferring to a family member, such as a child, then there could be an exemption for that property tax assessment. There's also the same exemption or similar exemption for transferring property into a living trust. And so if you form an estate plan, like we're talking about here, and you transfer property into it, there's not going to be a tax assessment. As long as the paperwork is properly filled out and filed, that will be avoided, which is a great thing. And so that's kind of the things that you want to avoid are these. Sometimes they sound like a good idea going into it, and then you find out, oh wait, there are some consequences that sometimes come about with these alternatives, such as joint tenancies. And so that's one real life example to talk about. I don't know did Kimberly have any others?
Yes, I have a very real life example. I want to talk about the hidden costs that you don't see. Like I mentioned, my father passed away, both my parents, but my father was the one I'm speaking about in 2020. And he had a house that he was living in, paying a mortgage on. He had bank accounts, he had annuities, he had cars, and he was very ill. We knew he was ill, so we were trying to get him to plan. Like, please make a will. I've made a will. We'll please update it. And I just started real estate. I knew nothing about a trust. He was sick for a year and he passed without doing any of that. So the hidden costs that you might not know about is during those 2 years, my sister and I not only had to pay for all of our flights to go down there and go through his house dispossession and deal with all of that and take time off of work and all the things you do when a parent passes, we had to pay the mortgage on the house for a year and a half, all the bills that go along with that, the taxes. We had to pay for the probate attorney out of our own pocket, because if the bank accounts aren't payable upon death to a beneficiary, they go into the estate. So those got held back until everything is done. We had to deal with all the creditors. We had to make phone calls to all the hospital. It was just crazy. And if he would have put a plan in place, that would have saved us a lot of heartache. If you have parents who maybe have a will but don't have a home in a trust, like what Adam's talking about, I would highly suggest, sitting down with them, send them this recording. Parents, if someone said this to you, do what you got to do so that you don't, your children aren't left holding the bag for all this. Because luckily my sister and I had the funds to do this, but not everyone does.
That's a great point, Kimberly, is also the non-financial costs that we're talking about is the time and turmoil that people have to spend, in picking up the pieces after the loved one passes. And with the formation of an estate plan, it's already taken care of or predetermined so that there's a plan going into it to prevent that scramble after the fact. So that's awesome example. Yep.
It's hard enough to grieve a parent without having to deal with finances and paperwork and all that stuff. It's just, get your stuff together for your children and help your parents get it together for you.
Yep. Responsible thing to do. Yep. Awesome. We can go to the next slide. And this is about creating a living trust. And so one of the first steps is engaging a professional. So you want to hire a licensed estate planning attorney. You generally want to avoid online forms or generic forms that, may miss nuances or things that you may not foresee. And also I will say that things change over time. Tax laws change and other things will change that could influence the formation of trusts. And so it's important to stay up to date on those, basically. And the next step would be to inventory your assets. And so you can list out all of your real estate, your accounts, valuable property, And then it's important to check how each asset is currently titled so that your professional can go about transferring them into the trust upon creating it. And you can decide the key roles within the estate, which would be, who's going to be your successor trustee to manage the assets, any guardians for minor children that you may have. And then, of course, it's important to have backups for both of these. And so if, a named trustee is also incapacitated and you're also incapacitated, then somebody else would be the alternative to step in. And that's just one example. And then, after these things are talked about or determined, then your estate professional can put together the estate documents. You'll be signing them, including a trust, portable will, power of attorney, healthcare directives. And then with these, the notarization is key for them to be valid in California. And then the next step we talked about was funding the trust. And it's crucial to transfer the assets into the trust after it's formed. And your estate professional can handle that for you to make sure it's done properly, and also to make sure that the potential downfalls are avoided, such as the property tax assessments that could happen if it's not done correctly, and things of that nature. And the other thing I'll note is that it's almost one of those things where it's something to circle back to every once in a while. So every couple of years, make a note for yourself that it's a good idea to rethink about, if you already took the responsible thing of forming a living trust, the next thing to do is have those little check-ins and figure out for yourself, are there any other property that I've acquired since then that I need to transfer into it? And so it's kind of like this maintenance or upkeep that goes a long way so that things are accounted for. And
Okay.
Yep.
Oh, go ahead. Were you done?
Yep, all done.
Okay, I just had a question on this slide, Ada.
Sure.
So how long does this take approximately? So say I'm someone that, okay, I call you tomorrow, I look online or I just reference this call and say, I want a California licensed estate planning attorney. And then Adam is your guy. And I call you, how long would it take to get going with this?
That's a good question. It could generally take about a couple weeks. If could take about a week or so to set up the documents. It could take another week or so to transfer the property in California, to go through the county records office. It's generally about a week turnaround for documents to get recorded for property titles. And so if everything's in place and all the ducks are in a row, it could take about a couple weeks. But then again, it's one of those things that attorneys always say, it depends. And it's annoying for people, but it depends if there's assets out of state or there's other changes that are made, then it could impact the time to form it.
Okay, great. Thanks for clarifying. That was faster than I thought it was going to be. So thank
Yep.
you.
Sure.
And someone else had a question. I know we went over this earlier, but someone said, why is the estimated cost for estate plan cost $5,000?
Yeah, good question. It's basically that's what the attorney will generally charge as, the fee for forming the estate plan. And again, it depends on the nature of the estate and if it's going to be something, easy, generic to put together. It could be potentially a flat rate at generally that cost, or a ballpark is basically what I'm giving here. If, there's a more complex estate or there's issues to be accounted for, or, pending litigation or things like that, it can get more complicated. And generally, it could be an hourly type of assessment that would be made. And so it's something that you'd have to get in touch with an attorney about to get that quote. But these are ballpark numbers that we're talking about here as comparison.
I think your hand is raised.
Good question. And it's really up to you. You could leave it like that, or there are benefits to transferring it into the trust, because basically it's protected by all the other terms and clauses within the trust document itself. And that means that, somebody could manage it on your behalf in the event that you become incapacitated. You could name alternative trustees. You could name alternative beneficiaries. And so it can be you can have a little more control and to have those nuances within a living trust. And so that's the short answer to your question.
All right.
Great. So we'll go to the next slide is real estate and probate. And so I guess this is touching upon what happens to real estate if it does go to probate. And basically, it can be a complex process sometimes, involving court approval, appraisals, potential delays. Understanding the necessary steps and regulations in California can help beneficiaries navigate this challenging situation effectively and ensure smoother transactions. And I'm sure David and Kimberly can attest to that in their experience, because properties are generally sold as is, often without any repairs or much access for inspections. And sometimes those inspections could be limited. And during the process, properties could be sold through various methods, including MLS listings, utilizing real estate agents. It could be a private sale involving newspaper ads, public auction. In basically making these sales, the price is anchored by the probate's referee, who will make an appraisal of the property. And typically, if an offer is presented, it needs to be within about the ballpark of 90% of the appraised value of the property for it to be accepted. And so that means you can't really lowball the probate property and, throw in a low value offer. You kind of have to stick around that 90% marker of the appraised value. And sale of real estate within probate typically occurs within months 3 and 9 of the probate case, but could take over a year. And when we say it could take over a year, it's typically cases where there's family members fighting over the property or claims made to the estate, and things are drawn out within the probate court. And so that's why, these are all subject to change or circumstances. There's never like a clear-cut answer of how long it takes, but these are the general ballpark estimates of it. And usually after the estate professional is appointed, a probate referee will appraise the value of the property, and then a trusted real estate agent, such as David or Kimberly, will list the property on MLS. And once an offer is accepted, the buyer places a 10% non-refundable deposit via cashier's check to ensure that they're going to follow through with their obligation. And then court approval for the sale could be required. And when we say it could be required, it's one of those things that's situational. If the estate is contested or not, there could be different nuances here that come into play throughout the process. But it could be required, for the court to approve the sale as a safety mechanism, basically, before it's actually sold. And then after, the escrow will actually close. And so it's a more drawn out process than, estate being set up. And this is just the general overview of what the process looks like.
Yeah, I again have some experience in this as well. So, like I mentioned, I went through this with my father, but we've also sold and helped buyers in probate. And we could, of course, have a whole other class about how to buy a property that's in probate, but that's not for here today. What I do want to mention, what can happen again if a loved one or you yourself pass away and your home isn't in the trust and it has to go through probate. So it could be regular probate or court confirmation, and those can both take a very long time. An example that a deal I'm working on right now, this gentleman passed away in July of 2024. So not last year, the year before that. We weren't able to bring the property to market until last year. So it took a year. And because it was court confirmation, we had this 90% that we had to stay within. And these referees, they just drive by and they look at similar properties. Now, this particular property was in great disrepair. It was not at all the same value as the other ones that had sold because it was really, really bad shape. So in order for, if we put it on the property at that price and in that condition, it would have sat there probably for another year or two. So instead, the family had to put money into the property and completely renovate it, which took, again, a long time. All the new stove, new refrigerator, family members paying for this. And then we finally get it on the market. And again, whoever's buying this home, they have to have 10% down. Now, in California, that's a lot of money. So you're already losing a lot of potential buyers. So it sits even longer. And during that time, the family's still paying HOA, they're still paying all the utilities and all that. It's a lot, right? Even if it's, a distant relative, the people who are taking care of this are distant relatives because this gentleman did have a trustee, but she herself is now incapacitated. So, like Adam mentioned, it goes on to the next person. Always try to have a plan in place for what if this person can't help.
Yep. Great example.
Yeah, and I do want to say that Kimberly did a great job with that. I know the goal of this call is not to get into probate ever, but Kimberly, you did a great job with those 2 transactions that we have with probate. So you're the expert there. But again, let's not get into probate. Let's talk to Adam first.
Yep.
All right. Any questions anyone has, feel free to unmute yourself, or you could throw it in the chat if you don't want to ask it out loud. You can raise your hand, either way, whatever works.
I think I see one in the, oh, it's you.
That was me and my friendly message. So yes, just you can unmute yourself or throw it in the chat.
It depends on how you want to navigate it. In California, generally these kind of things overlap with basically it's what's called it's marital law. And so basically, if you're married and if things acquired during the marriage are considered your marital assets. And so they have rights to it if, they come before it's actually acquired. But before that, it's your own separate property. And so you have the power to designate, who you want to give it to because it's your own separate property. And so if you want to be generous and give them something, you could update the living trust to say, yes, I do want to include this person in my estate plan for these assets that were acquired before the marriage. But that's completely your decision. So you don't really have to. And so there's nuances to this. And it could be one of those things that is, like we talked about, the maintenance of an estate plan, that is something to be considered later on. So if you grow closer to that person and, have a better relationship with them, maybe you'd have more of a wanting to include them within your estate. It sounds like it's one of those things that's a little bit out of your control. If it's already his property, it's up to him on how he wants to distribute it, or if he wants to include her or not in the estate plan, or keep it as his own separate property. If he were smart, he'd probably keep it as a separate property. You probably hope for that so that it goes to your kids. But then again, it's one of those things we don't have control over, unfortunately. There potentially could be, and it could be one of those nuances, with a tax professional to determine if there's something that's more beneficial or not. In general, a non-revocable trust is locked in, and versus a living trust can be changed throughout your lifetime, and then it becomes irrevocable in the event of your passing or you becoming incapacitated. And so they're just basically different mechanisms to be considered. And so just subtle nuances between the two.
I have a question. Kimberly, you stated a few slides ago that you would need to change your insurance. Can you elaborate on that a little bit?
As Adam has told us before, I'm not an insurance professional.
Yep.
The insurance is tied to the owner of the home. And if the trust is now the owner, so for instance, a lot of people during the fires that we recently had weren't able to collect insurance because they had set up trusts and not transferred things. I don't know if Adam, if you help with that, but it's just a simple call to your insurance agent and say, hey, there's now a new owner and it's the trust.
That's exactly what it is. And basically it's important that not only, real property is transferred, but also things like accounts are named have the trust name appearing within it. So then there's a signal that it's owned by the trust rather than the individual person. And so that's the same situation with the insurance, to make sure that it's owned by the trust within the actual name displayed.
Got it. And when you're making those calls and trying to make that change, would that also require that you send them the trusts as well? Do you know?
A lot of times, yes, they will want a copy of it to record it. And it's one of those, it depends on the entity and their policies type of thing. But they could ask for a copy. That could be something that happens.
All right. Any other questions? We're right on time, which is perfect, but we still got the time for a question if anyone has it. And if not, we will move.
And so if anybody here is strongly considering a trust or an estate plan, feel free to reach out to me. My name is Adam Carpinelli. This is my phone number, 760-607-6870. Oftentimes, attorneys are weary to give out their phone numbers, but I'm willing to do that for you guys, being that you're here and listen to the presentation. So more than happy to help you guys and answer any questions you may have that come up, after this presentation.
And Adam, if someone, let's say, has parents who they know have not made a plan and they live in, let's say, Arkansas, do you have a network of attorneys where you could refer them an estate attorney in Arkansas, or is that something that you can do or no?
Yeah, definitely. There's professionals we can reach out to or connect you guys with. So we're happy to help with that process too.
Great.
All right. Thank you all for joining the call today. This is a good one to take a screenshot of. Also have Adam's info on here. He's the main person right now. So make sure you take a screenshot of this page. And thank you all for joining us today. Also, if you guys have, for anyone that's not a tech person, you could take your phone and then you go to the camera function. You go over these QR codes. This is for Kimberly and I. Maybe Adam gave you his phone number. That's good enough. But for us, you also have our Instagram. We post a lot of stuff about real estate, trust and probate, and then also just a little bit about us. So hopefully you could join us there. We'd love to have you. And then Kimberly, anything else you want to talk about that?
No, I'll do my wrap up at the last slide. I'll say my goodbyes then.
Perfect.
Obviously, we're real estate agents and we would love to help you if you need to sell or buy property. And if unfortunately you are in the situation where a parent or a loved one has passed, we would love to help you with that too. I know personally, I've been through it. I know it's such a difficult situation. So we handle it with care and finesse, a lot of hand holding because it's just a really difficult time and it's so hard to deal with that. And all the stuff like, checking off the checklist of things you have to do. So we're here to help you with that as well.
Yes. And then also, I know a lot of you are part of our community already, but if you're not, then feel free to join us here. You could also do this thing I just taught you, this technology here with the camera. You could scan over it and you'll see that's how you could join some of our groups. I do a lot of stuff with, obviously there's some real estate in here. We do some happy hours, some fun speed dating, paddleboarding and golf and a lot of stuff. So if you don't join us there, then you can. And then Kimberly has amazing groups, arguably better than mine. She's very creative and she comes up with some really cool events. Yeah. So I'll give you credit for that, Kimberly.
Thank you. Thank you. I learned about running meetup groups from David. Thank you for your knowledge. But yeah, I do run these two groups. They're a lot of fun. We do weekly events. So if you have a dog and that alcohol-free group, you don't have to be a sober person. We just don't drink at the actual events. So you actually go in and you're just yourself, which is really nice just to be present and be there.
Yes. All right. And then also speaking of real estate, we do have different calls. We just added this call right now, this trust and probate. So thank you again, Adam, for this. But we do offer calls. So for first-time home buyers and sellers seminar, where we go over that. We also do tax benefits. That CPA that Adam was talking about, we do have a CPA where we do go on calls and he'll teach us about the tax benefits, and good one for you guys to join. If you scan this QR code or go to livingcahome.com, you'll also be notified that way. And then Kimberly's going to post it in her meetup groups as well. So you'll be able to see all that. All right. I think we're all going to say our goodbyes, but thank you so much for joining us today.
Thank you so much for joining. I know this is a hard subject to think about, either your death or your parents' death. And it's really difficult to have this conversation with parents. I know I've had it, but I can tell you, you have to have it. You really have to sit them down and say, this is something we have to do. And it's a hard conversation, but it needs to be done. Also, I would like to say there's a book on Amazon called I'm Dead Now What, which is a fantastic book where you can actually write out all of your plans just so everyone can know without having to, you still have to need the attorneys, but it's just a really nice thing to maybe start the conversation. I have it. I gave it to my parents. I gave it to my in-laws. Fantastic book. Highly recommend. And then I'll turn it over to Adam. And thank you so much, Adam, for all of the information. We really appreciate it.
Yeah, thank you guys so much for having me. And a great point, Kimberly, of, one of the main points of giving this presentation is to gain awareness within the community of the importance of setting these things up for yourself and your loved ones. And so we hope that you guys consider that, spread it to your loved ones and have that conversation with them and ask them, is this something you thought about? Is this something that you would want to set up so that they are planning for themselves and their heirs? And it's generally peace of mind, basically, that you're buying in the process. And so it's highly recommended. And again, thank you guys for coming. And yes, get out there, enjoy that nice weather. And hopefully we'll see David and Kimberly at some of these events coming up because they are amazing.
Yeah. We will
Yep.
be there. And then thank you again for all joining. What we're going to do is stop the recording now. Anyone that is here live, we're going to allow you to ask questions now too, because sometimes people don't want to do it while the call is being recorded. So I'm going to end the recording right now.